Thank you, Mr. Chairman. And I want to, at a little bit of risk, say that I don't entirely agree with all of the comments that the preceding speaker made, notwithstanding the fact that he's on my side. It is my view that Part 4 is necessary. There is no doubt in my mind that there has to be a granting of urgent approvals approach, and the example that I've given of a building, there might well be an occasion where it's appropriate to have one bowled quickly, or the transport issue. There might well be as a result of a foul up at the opening. A decision that there's a need to do some road closures later on, and therefore for the semi-finals and the finals, and an urgent process is necessary. So I don't think there's a debate about the need for having an urgent process. It is just the way that it is shaped, and in particular, I think, Mr. Chairman, if you look to clauses 52 and 53. The differences in approach between those two clauses. One is the effective declarations that are made by order in council, and the second is the effect of urgent approval granted by a minister. They are quite different. Mr. Chairman, I see no problem. I can't remember if you, Sue, were involved, Mr. Chairman, while you were a minister, but I was on occasion part of very hurriedly put together executive council meetings to pass orders in council. Statutory management is the obvious example, but there is an ability for a government, if necessary, to get three ministers together in order to form an executive council to pass orders in council. But I think in doing that process, what you do is you ensure a sense of collective responsibility, and you make sure that there is a check and a balance on a particular individual minister, rather than letting them run without the checks that are here. I will point out that there have been some useful changes made in this, especially around the terms and conditions, the payment of a bond, and that bond, unlike the deposits for the Part 3 declarations, the deposits for this, or the bonds for the Part 4 declarations, are in fact such that there can be a deposit around not only the cost of the hearings, but to secure the costs of any remediation of work that is done, and to make sure that the conditions of the urgent approval are in fact met. And I think that's relatively unusual in New Zealand law. I think it occasionally happens with oil companies, but because it is very unusual power, I think the Select Committee did a good thing in making sure that there was a bonding arrangement, therefore some of the rorts couldn't occur. Mr. Chairman, the authority in making its recommendations, and the Minister in granting an application, as happens, has to look to a number of factors, and one is the need to secure public safety, to avoid, control or mitigate any adverse impacts of Rugby World Cup permitted activity on the environment. Those were additions that were made by the Select Committee, because what the Select Committee saw was that it was important, exceptionally important, in these urgent cases, that and they will be irreversible, Mr. Chairman. This is a large part. This is the key bit of the legislation, because everything else in the legislation, Part 3, there is time to appeal, there is a time to reverse, there's an ability, at least on points of law, Mr. Chairman.
I call the Honourable Trevor Mallard.
Mr. Chairman, there will be, at least on points of law, the ability to get to a court, but in 54.4 it makes it clear that a decision under this section on the part of the Minister is final, and using the example that we have on a number of occasions, it could well be that a decision is signed by a Minister at 11:59 and at 12 o'clock bulldozers start to move. So there's not the ability to intervene, to use court processes in order to review or to hold. And Mr. Chairman, that therefore is very, very serious. I think we do need to focus as well, and I'll be interested in government members' opinion, possibly the Attorney's opinion on clause 53, subclause 2. And that is the clause that is designed to make it clear that any right that's based on one of these approvals does not give any right based on the use of the land after the expiry of the approval. Now, that's all very well and good to say that a right doesn't give you any rights afterwards. But if you've demolished a building in order to make a fan space, then there can't obviously be, if it's a historic building, a requirement to replace the building in the form that it was. So a lot of this ends up being very, very final. I want also to say that I think the Minister got it right in the introduction of this legislation after discussions with the Labour opposition to have a requirement under 51.1 A and especially B to consult relevant ministers. So when a minister gets a declaration from the authority, there is then a requirement on the minister to go to his colleague, in this case Mr Brownlee, and then to go to any Minister of the Crown, and I think generally it would likely to be the Minister for the Environment or the Minister for Conservation, are the two who I think are most likely, because they are the ones who are holding the powers. There might be occasions, and I'll be interested again in the view of the Minister and the Chair as to whether the Minister of Agriculture might be consulted if there's a biosecurity issue, whether the Minister for Biosecurity is someone who might become involved, or in other cases the question, there might be a commerce question, there might be a competition question, and I'd be interested again in the views of Mr Power as to whether or not he envisages becoming involved in this. But, Mr Chairman, I think it is also important, and there is a question of whether there is, in subpart 2 miscellaneous provisions, a subpart of this part, a misplaced clause 52, whether in fact this should be earlier in the legislation, because the implication of this is that it relates to part 4 when in fact the 52 relates to part 3, and it's a question, there could well be confusion with the Act later on. I'd be interested in opinion on that, whether it would be better drafted in an order where the regulation explanation clause, it's not the regulation making one, because that's in clause 48, which is earlier and is in the in the bill, whether it would have been better to have that sitting in the appropriate place. Mr Chairman, this is the second of my sets of calls, and I would like to finish this call on the same basis as I did my first, and that is with a challenge to government members to give us a specific example of where they think a Minister of the Crown should have the right to, on his own accord, against the view of a judge, and a panel.